Good afternoon, everyone, and thank you for joining us today. My name is Mike Straczynski, and I'm Executive Vice President and General Counsel for the Massachusetts Health and Hospital Association. On behalf of the entire MHA team, I want to welcome you to today's webinar, an update on the FTC's non-compete ban. A few logistics before we start. If you have questions during the webinar, please enter them into the chat feature, as we are in a listen-only mode. Questions will come directly to us. We'll do our best to address as many as we can at the end of the presentation. I also want to take a moment now to thank MHA's 2024 annual sponsors and strategic business partners for their support in underwriting today's webinar. This is just one of many events we have to offer throughout the year to connect our members with leading experts on timely issues like the one today. I'm now pleased to introduce our speaker from Foley & Lardner, Benjamin Dryden. Ben is an antitrust lawyer and partner at Foley & Lardner, and he also serves as the vice chair of Foley & Lardner's Antitrust and Competition Practice Group. His practice is largely centered on antitrust issues that arise in mergers and acquisitions. Ben's experience includes counseling clients through due diligence and integration planning processes, negotiating antitrust risk provisions in purchase agreements, and more. And he has a particular focus with transactions in the hospital, health insurance, and manufacturing sectors. At MHA, we've been able to witness Ben's excellence firsthand as he guides the association on antitrust matters. Ben, thank you very much for taking the time to join us today for this discussion, and I'll hand it over to you now to get us started.
Great. Thank you, Mike, and thank you, everybody, for joining today. I'm Ben Dryden with Foley & Lardner, and Mike just introduced me, so I won't do that again. We're here today to discuss the FTC's recent adoption of a rule banning employee non-compete agreements. And so I've got some slides to walk through to describe the rule and where we are and where we are going. So without further delay, let's jump right in. There we go. All right. And as Mike said, if there are any questions, use the chat. Happy to field questions at the end of the discussion. And there's a lot to unpack, so feel free to ask away. So just the agenda for today, we're going to discuss the current law, particularly in Massachusetts, because Massachusetts already makes it difficult to have employee non-compete agreements. But then we're going to pivot to discussing the FTC's rule and describing the parameters of the FTC's ban on non-competes and the exceptions. And the exceptions are pretty interesting, particularly for not-for-profit healthcare systems, which I know that most of the folks listening today are. And then we're going to talk about what happens next, because the FTC's rule is just the start of the process, not the end of the process. It's in litigation. So it's going to be a very interesting couple months to see where this goes. But we'll begin by talking about the historical regulation of non-compete agreements. And non-compete agreements, and we're talking about agreements that prohibit a employee after the end of their employment from taking a job for a competitor. So if you are company A and you have a competitor B, the non-compete agreement says my employee after the end of their term employment with me will not be able to go work for B or any other competitor for a period of 6 months, 12 months, whatever the period is. That's what we're talking about, an employee non-compete agreement. These agreements go back centuries, I mean, going back to English common law. And there are English common law cases from the 1700s where judges in the 1700s are deliberating over, should this agreement be valid? And it poses an interesting question, because it really goes to the freedom of an employee to contract in a way that restricts their future freedom. It's an interesting question. And as you can imagine, the absence of, until just what the FTC did, in the absence of a federal rule, every state has drawn kind of its own unique rule. And so historically, employee non-compete agreements, and I'll say NCA for short and for brevity in the presentation. So an NCA is an employee non-compete agreement. Historically, NCAs have been subject to a very interesting patchwork of state-by-state rules. And there are some states, namely California, North Dakota, Oklahoma, and as of last year, Minnesota, that just say, NCAs are banned as contrary to public policy. And there's some speculation that the reason Silicon Valley has been so successful is because there's no friction to employees going from one company to another company to another company to another company. And that's a thesis that has been argued for decades that freeing people from non-compete agreements really is good for the macro economy and helps businesses get formed and innovate and grow. And so that's really where the FTC is coming from. But that's one approach. Other states say, no, we're going to look at non-competes on a case-by-case basis. And a lot of states don't even have a law on the books on non-competes. It's a common law thing that falls on the shoulders of judges on a case-by-case basis to decide under the facts of that particular case, is this particular non-compete agreement reasonable or not? Does it offend public policy or should it be enforced? And yet other states do have statutes on the books, and the statutes will dictate specifically what lines the state legislatures adopted to determine whether a non-compete should be enforceable or not. And that's the approach the Commonwealth of Massachusetts has taken. So Massachusetts, and this has changed over the past even 10 years, Massachusetts, as of right now, is fairly hostile to non-compete agreements. Massachusetts categorically bans non-compete agreements for employees who are not exempt from the Fair Labor Standards Act, meaning if you're eligible to earn time and a half for working more than 40 hours a week, then you are not eligible to sign a non-compete agreement. Non-competes are only permissible for FLSA exempt employees. Massachusetts also bans non-compete agreements for employees who are terminated without cause. If there are layoffs and it's not the employee's fault that they're no longer employed, then in that case, a non-compete agreement is void. Massachusetts also bans non-compete agreements for minors or for student interns. Outside of those categories, Massachusetts will enforce non-compete so long as they meet 5 elements. And these elements are quite difficult to meet. One is that the non-compete has to be narrowly tailored to protect a legitimate business interest. And that's the general standard of even the states that evaluate non-competes on a case-by-case basis. They typically will adopt a reasonableness test. Is there a legitimate business interest being served? Then in Massachusetts, the non-compete has to be reasonably limited in time, space, and scope, with a presumption that 12 months is the outer limit of a reasonable time, and that the space is where the employee was performing services during the time of their employment, and the scope is the scope of the services that the employee was performing at least within the past 2 years before the end of their employment. This is the one that really trips up companies. In Massachusetts, a non-compete agreement has to be supported by consideration. It can't just be that this is a condition of working for us, you sign a non-compete. There actually has to be bargained for consideration. And the state statute gives the example of you will pay someone 50% of their prior salary during a leave period at the end of their employment. So for instance, you want someone to not compete with you for 6 months after the end of the employment. The arrangement has to be that I'll pay you half of your salary during those 6 months while you're out waiting for your next job. So that's one that there's not a lot of states that have a rule like that. And that's one that really in practice limits the prevalence of non-compete agreements in Massachusetts. The other 2 requirements are that the non-compete has to be consonant with public policy. And in Massachusetts, I like this one, that the non-compete has to have been provided to the employee at least 10 days in advance, and they have an opportunity to consult with counsel and just read up on their rights before they sign the non-compete. So this is the general rule in Massachusetts, but specific to the healthcare sector, there are even further restrictions. So in Massachusetts, nurse non-competes are broadly banned, at least with respect to non-competes for registered nurses or practical nurses or licensed practical nurses. Under the Massachusetts general laws, those are banned. Also, physician non-compete agreements are broadly banned in Massachusetts. Also, non-competes for psychologists and for social workers are broadly banned. Even if they check the 5 boxes on the previous slide, Massachusetts just broadly bans them. So we're starting from a place where Massachusetts does not entertain many non-compete agreements. But with that, we'll pivot to what the FTC has done. The Federal Trade Commission, if you've never run into the Federal Trade Commission, it's just a primer on who they are. They're a 5-member commission. They're based in Washington, D.C., in a beautiful neoclassical building right on the National Mall with some of the best views in the city. And there's a big statue outside the building. I've got a picture of the statue here. It's Man Restraining Trade is the name of that statue. And it just speaks to the FTC's authority to be the federal regulator regulating trade. They have two fundamental charges. One is to prevent unfair methods of competition, which are things that sound like antitrust violations, but is broader than that. They also have the charge of preventing unfair and deceptive acts or practices in or affecting commerce, which are consumer protection type violations. Deception in advertising falls on the FTC to prevent. What this means is the FTC has a pretty broad portfolio of powers, but in the area of antitrust enforcement, which is the relevant one here, they have the power to prevent antitrust violations, but also they have the power to prevent unfair methods of competition, which is broader than things that strictly violate the antitrust laws. It's a very live issue. Well, how much broader than the antitrust laws is the FTC's charge? Again, very hot issue. Jump forward to 2021, President Biden signed an executive order. The title of the executive order was Promoting Competition in the American Economy, and it called for a whole of government effort to take regulatory steps to promote competition in the economy. There were 72 different directives included in the executive order, but really the headline one was the president called on the chair of the Federal Trade Commission. The chair of the FTC is a woman by the name of Lena Khan. She's in this picture watching the president sign the executive order. She's the second from the left. The chair of the FTC is encouraged to consider working with the rest of the FTC, the rest of the commission, to exercise the FTC's statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses. And other clauses or agreements that may unfairly limit worker mobility. So coming out of that executive order, the FTC embarked on a multi-year rulemaking process, which finally culminated in April of this year, when the FTC voted 3-2, with the 3 Democratic members of the commission voting for the rule and the 2 Republican members voting against it. They voted to adopt what we call the non-compete rule. The FTC, in the course of this multi-year fact-finding and rulemaking process, made a number of factual determinations. And we can quibble about whether these are right or wrong, but according to the FTC and their research and their expert economists, they have found that a broad ban on non-competes will have a number of pretty sweeping effects that, in the FTC's view, are good effects, things that will promote competition, namely increasing wages by between $400 and $488 billion over the next 10 years, averaging over $500 per worker per year in extra pay. They found that banning non-competes will create 8,500 new businesses each year, an additional 17,000 to 29,000 new patents per year. This again harkens back to the thesis that the reason Silicon Valley has been so successful over the past 3 decades is because of the ban on non-competes. They're leaning into that thesis. Interestingly, the FTC also found that banning non-competes will reduce spending on physician services by between 74 and 194 billion. That's based on a particular academic study. Now, we can just pause here and say that in the same breath, the FTC is saying that banning non-competes will result in higher wages, but less spending. So I was having a discussion with someone about this a couple of weeks ago, and they said, well, this is monopoly money. And there's two possible takeaways from that. Either this is all made up money, it's monopoly money, as in it's not real, these are just made up numbers, or it's monopoly money in the sense that there is a catastrophic market failure in the current state of our free market, where employers are just holding on to money that rightfully belongs to employees, and they're using non-compete agreements not to pay people their fair desert. And so the FTC is making that argument, saying that there is a market failure and this rule is needed to cure that. So let's talk about what the rule actually says. The rule broadly bans employee non-compete agreements. For about 99% of workers, the non-compete rule just declares it categorically to be an unfair method of competition prohibited by the Federal Trade Commission Act to enter into, to enforce, or to represent that a worker is subject to a non-compete clause. The term worker is defined very broadly, includes not only employees, but former employees, interns, volunteers, independent contractors, sole proprietors. A non-compete clause is defined as any term or condition that prohibits, penalizes, or functions to prevent a worker from seeking or accepting a job in the United States with a different employer or operating a business, namely starting a new business after the end of their employment. For 99% of workers, any non-compete agreement like that is banned. There is, for less than 1% of workers, that's the FTC's estimate, there's a small exception. For workers who qualify as senior executives, and I've got the definition of senior executive at the bottom of the page here. It's basically you have to make more than $151,000 in the previous year, and you have to have C-suite authority. There's a lot of people who make more than that salary threshold who do not have C-suite authority. You've got to have both to be a senior executive. But if you have both, then for senior executives, the non-compete ban still applies, but it only applies prospectively, not retroactively. Let me unpack that. The FTC found that in the case of senior executives, it is a little bit less unfair to bind someone to a non-compete agreement than it is to bind a non-senior executive. The logic being senior executives are sophisticated and they have some degree of bargaining power to negotiate a square deal with their employer. What the FTC found offensive about non-compete agreements and senior executives is that senior executives are the people who are most likely to quit their job and then go work for a startup or start their own startup. So the FTC found that the harm to competition caused by non-compete agreements on senior executives is meaningful, but they said that it's a little bit less unfair than other non-compete agreements. We're going to draw a slightly different rule. And the rule is for a non-compete agreement entered into before the FTC rule takes effect, the effective date slated to be September 4th. If a non-compete agreement is signed before the effective date, then it's valid. It can continue to be enforced, but after September 4th, 2024, under the FTC rule, it will be improper to sign a non-compete agreement with the senior executive going forward. There's a notice requirement in the rule for all the employees who are subject to non-compete agreements, even if the non-compete agreement has never been enforced, even if the non-compete agreement has been superseded by state law, and maybe it's a 20-year-old agreement, but the law has changed, you just never revised the agreement. The FTC rule requires affirmatively notifying employees that their non-compete agreement cannot be enforced and will not be enforced. And they have model language, and I've got the model language on the screen. We'll send this deck around afterwards, so you'll have it. But there's a affirmative obligation to notify employees that their non-compete agreement's no longer in place. Exceptions. There are a couple of exceptions built into the FTC rule, and then there are a few other broader exceptions. So I'll start with the explicit exceptions. One, this is a big one. The non-compete rule does not apply when it was entered into pursuant to a bona fide sale of a business entity. So if I own a physician practice and I sell it, I am in that case able to say, I'm not going to go quit immediately after selling my business and found a new physician practice that competes with the business that I just sold. That's a well-established rule, even in states like California, where non-compete agreements are broadly banned. Even California makes an exception in the connection with the sale of a business. So the FTC has preserved that exception to the rule. Non-competes are permissible when made in connection with the sale of a business. There's some caveats around that, but the concept holds. Another exception is the non-compete rule does not apply where a cause of action related to a non-compete clause accrued prior to the effective date of the rule, which is a lawyerly way of saying, if a non-compete was breached 6 months ago and the non-compete was valid 6 months ago, this FTC rule doesn't have retroactive effect, that you can't forgive someone for breaching a non-compete agreement that was valid 6 months ago. It only applies going forward. And then there's a last exception, a final exception, that if someone tries to enforce or make a representation about a non-compete agreement being valid for any reason, as long as there's a good faith reason for holding that belief, then there's an exception to the prohibition on enforcing or representing the workers subject to a non-compete agreement. Basically, if you have a good faith belief that a non-compete is enforceable, then you can act on that good faith belief without running afoul of a non-compete rule. Those are the explicit exceptions. I think more interesting is there are some just statutory exceptions, one of which is really, really important for healthcare. So this all comes from the Federal Trade Commission is charged with preventing unfair methods of competition. This is a statute that dates back 110 years. It's an oddly worded statute. And I've got the language of the statute here. So the commission is hereby empowered and directed to prevent persons, partnerships, or corporations from using unfair methods of competition. But there's a big gap in there. There are exceptions. And the reasons for the exceptions is sometimes there are other federal laws that govern certain types of businesses. So banks, savings and loan institutions, federal credit unions, common carriers like phone companies, air carriers. All of these companies fall outside the scope of the FTC's jurisdiction to prevent unfair methods of competition. So banks, credit unions, phone companies, airlines are not going to be subject to the non-compete ban. There's also persons, partnerships, or corporations subject to the Packers and Stockyards Act, an esoteric law about livestock dealerships. And so I think of that statue outside the FTC building, the man restraining trade. If that man who's corralling that horse is a livestock dealer, then that man is not subject to the non-compete rule. Additionally, notice that the lead in the statute is the commission's empowered and directed to prevent persons, partnerships, or corporations from using unfair methods of competition. Well, arguably that doesn't apply to, say, a government employer. So a government-run hospital might not be subject to the non-compete ban. Likewise, corporation is defined, I've got the language here, as an entity that's organized to carry on business for its own profit or that of its members. What that means is that nonprofit corporations are not subject to the FTC's jurisdiction to prevent unfair methods of competition, which means nonprofits are not subject to the non-compete ban. That's a problem for the FTC because the FTC really was trying to prevent non-competes in the healthcare sector. A lot of the rulemaking was focused on perceived abuses caused by non-competes in the healthcare industry. But as we all know, a majority of the healthcare, at least the hospital sector, is made up of not-for-profit healthcare providers. And so the FTC explained in their rulemaking notice, sometimes we do have jurisdiction over not-for-profits. They gave the example of a physician hospital organization that, while organized as a tax-exempt entity, is trying to negotiate managed care contracts for the financial benefit of its private for-profit members. In that case, the FTC has gotten jurisdiction. So it's a touchy issue, but basically the FTC is a two-part test for determining whether you're a true nonprofit or a nonprofit that is subject to the FTC's Act. The test is there an adequate nexus between your activities and your public purpose? And are the net proceeds of the organization being properly devoted to bona fide public rather than private interests? Really uncharted waters. This has not been fully litigated, but what the FTC does say in their rulemaking notice is, okay, even if you're a not-for-profit, if you have a for-profit subsidiary, say a medical group that's organized as a for-profit, and that's the vehicle that you use to employ doctors, then that for-profit subsidiary is subject to our jurisdiction. It is subject to the non-compete rule. They also give the example of a for-profit staffing company that comes in and provides locums physicians on a third-party staffing basis. That third-party staffing company presumably is a for-profit. And so even if the doctors are working at a not-for-profit hospital, if their employer of record is a for-profit staffing company, then the non-compete rule applies. So what happens next? The FTC adopted this rule on a Tuesday afternoon in April. By Tuesday evening, they got sued in one court. By Wednesday afternoon, the next day, they got sued in another court. And by Thursday afternoon, they were sued in a third court. There are various plaintiffs, including the U.S. Chamber of Commerce, who are seeking to challenge the legality of this rule on a number of bases. I think the strongest argument, and there are a lot of arguments that have been made, the strongest argument to challenge the rules, they call the major questions doctrine, which is a doctrine that the Supreme Court has invoked over the past few years to invalidate student loan forgiveness and carbon dioxide regulation in situations where a regulatory agency is really grasping at a a vague language of an ancillary provision of their enabling act, or an agency uses some mouse hole to try to jam a regulatory elephant through. The Supreme Court has said, okay, for major policy questions, there has to be a really, really clear grant of congressional authority to the agency. And that's the argument that the plaintiffs are making, is that there's nothing like that here. The FTC is trying to micromanage an area that's been historically regulated by states, an area of employment law, using this power to prevent unfair methods of competition. They've never done anything like this before. So it's an interesting issue for litigation, and it's out. The case is currently very hot. We should have a decision by July 3rd on whether the rule is going to be preliminarily enjoined or not. Another kind of ancillary issue, which is germane to this audience, so I'll talk about it, is just what is the empirical support for the non-compete rule? And the FTC has found that all non-competes are always unfair methods of competition. That's the FTC's party line. But the economic literature is not nearly that cut and dry. And in fact, one of the best studies that was done was a longitudinal study of primary care physicians across 5 states, where they just sent surveys to primary care physicians across 5 states and just asked them, are you bound to a non-compete? What do you make? What was your earnings growth? And based on this methodology, these authors found that doctors actually make more money when they sign a non-compete, and they make more money to start, and they make more money as their career advances. There's a theory that, well, that you just need some cohesion to a medical practice to really make it a well-oiled machine where the left hand cooperates with the right, and the non-compete is the way that you protect patient relationships without worrying about doctors jumping ship and taking their panel of patients across the street. So it's an interesting issue. Where this leaves us, however, and this is the last substantive slide, is this can go 3 ways in the next couple of weeks. Either the court, it's a court in Texas, invalidates the FTC rule in its entirety, in which case we just go back to the status quo where we have this 50-state patchwork of different rules on non-competes, or the court will uphold the rule in its entirety, in which case non-competes go away. I should add that in this scenario, to the extent a state has laws that protect workers more than the FTC rule, those state laws would still remain in place. And that's arguably the case in Massachusetts, where there are things like notice requirements for non-compete agreements. It could be that a senior executive is subject to a non-compete agreement that passes the FTC's test, but was not provided with sufficient notice or something. And so that under that case, the non-compete would be void under Massachusetts' existing law. And the third scenario is chaos, that the court allows some non-competes to go forward, but not others. Or there's the one court in Texas issues one decision. There's another court in Pennsylvania that could issue a contrary decision. So it's going to be really interesting to watch, but it's a very live issue. I'll ask Mike, are there any questions, comments, or follow-up points?
Okay, we got like 2 minutes left here, Ben. Thanks. Folks watching, if you want to stick a question in the chat, we probably got a minute to answer it. But as you look into these legal challenges, if you were handicapping the outcome, where do you think it's going to fall?
I've been watching this very closely. I really, truly am persuaded by the major questions doctrine argument. I think there are 3 boxes for a major questions doctrine case, and this case roundly checks all 3 boxes. So I think it's likely that the court will invalidate the rule in its entirety on those grounds, but it's hard to say. And it's the type of thing that the plaintiffs who are challenging the rule don't want to win on the major questions doctrine. They want to win on a different hill. They want to invalidate the ability of the FTC to adopt any rules at all. And that's a much more difficult argument. Some of the case law goes against them. So when you lead with a bad argument, you have a good follow-up argument, I think, it'll be interesting. A lot of things can happen.
We'll stay tuned and And certainly pass through any questions, and we'll be posting this webinar as a recording as well. So I might have some follow-up to you, and anyone watching, if you do, please let us know. We can pass through those questions to Ben and get you some answers. But Ben, thank you very much for joining us today. A lot of great information really packed into that presentation. I think you hit every angle of this, and very helpful to me and those watching and understanding the new rule here. And thank you to all of you who tuned in. If you scan the QR code on your screen now, you'll see all of MHA's upcoming educational programs. We've got several events this summer, and we hope to see you at one again soon. Thank you very much. Have a wonderful afternoon, and stay cool.
Thank you.